tell or a question to ask?
I had a few questions. First off, Mr. Vincent, I've listened to days of your, if you put in all the hours I put in, I've listened days and weeks to all of your shows, all of your YouTube videos, and I just want to formally and publicly say thank you. Thank you to both of you. And Cynthia, I've watched so many of your stories. I don't think people take enough time to tell you how appreciative I am as a parent for all the free knowledge and all the time you've given to help parents like myself in my position. And I haven't heard many people tell you thank you. So first, I just want to thank you both from the bottom of my heart.
We appreciate that very much. Thank you.
Thank you very much.
I've called in a few times, Mr. Davis. Our son was taken without a warrant. He was at a nursery, a crisis nursery. CPS called the crisis nursery, told them that the mother and father were purposely being detained. The grandmother was on her way, and basically forced my mom to take my son in July, and a warrant wasn't actually put out for my son until September. So I'm very confident in the civil rights matter that we'll have to apply for, but right now I'm just focusing on my son. I know that, trying to represent myself would be, a fool's job, and I need legal representation. I've talked to 63 different law offices and sent out 17 different emails trying to get a free consultation at the very least. And most of the attorneys that I've talked to that do specialize in CPS, their caseloads are full and they're not accepting any more clients, or it's, $500 for a 30-minute consultation. So I'm going to get straight to the point with some of my questions. My first question is the investigator. When we first started, I took your advice. I told my legal counsel that was given by the state that a court-appointed investigator wanted to talk to me. I'd like her to be present. She's like, well, I'm really busy right now. He just works for the judge. He's coming to ask you questions. He's strictly for the judge. And that's what he said. He wasn't a CPS worker. Well, that was all BS. And, the report was basically just copied and pasted from the original social workers report. And that's evident due to the fact that in the original social workers report, she had my name wrong. And in the court-appointed investigators report, my name's still wrong. So you could tell it's just kind of copy and paste on some of the information. My next question is now my child's attorney wants to send out their own private investigator. Can I trust him, as I was told that I could have trusted the court-appointed investigator, or should I still take the following steps in requesting my attorney to be present during those questionings?
Well, it's always good for you to ask your attorney to be present. Now, if they can't be present, because they're court-appointed, I don't know what to say about that. Are your children with you or not with you?
No, my child is still with my mother at this time.
Okay, well, it's unusual for the child's attorney to want to come out and speak to you. First of all,
not to me. He's been talking to my mother during this, but he said that he had his own investigator that would be coming out to question.
To question your mom, but I hope not you.
Okay.
Because,
I haven't found that out yet.
Another attorney on a case can't talk to you without your attorney's permission and without your permission, and if this person is not on your side, you probably wouldn't want to talk to them without your attorney being present. I don't know the facts of your case, but that's just generally what I tell people.
Okay.
I'll give you an example. I have a client right now who has the children in his custody. And the minor's attorney called me and told me, why wasn't my client speaking to her investigator? And I told her, very nicely, I said, look, you and your office can't talk to my client. It's against the law without my permission. Right? So if you want to go out to his house and see the kids, that's great. Do it. You have that right to do it. But don't expect him to get into a conversation with you about the weather or the case or anything else.
Okay.
Okay. Now that's just my policy. So other attorneys do it differently, right?
Why am I see that every side has had their own investigator come out for, their defense. And my court-appointed attorney has made no mention of an investigator. Am I entitled to an investigator? I know usually in these cases, especially with court-appointed, if you don't ask, it's not going to be given.
Yeah. So hold on. I can answer that question. It depends upon your court-appointed attorney's office. Now, in Los Angeles, court-appointed attorneys, from what I understand and remember, they do have their own investigators. They don't have a lot of them, so there's a shortage of them, I think. But your attorney's office may have an investigator that can go out and investigate the case. But you don't have the right to that. So, sometimes attorneys can give you resources. Sometimes they can't. And if they don't, and you want your own investigator, then I would talk to your attorney and find out if you can, maybe hire one or get one to help defend you in this case.
Okay. My next question, there was no prima facie that was given in the reports. All of the reports are, and it's specifically stated in the medical reports, all the urine analysis came back negative. I was hospitalized. The report says I was high on drugs, but the hospital records show that they tested my system, that it all came back negative, and there was just a suspicion. And they're just basically going off of accounts of suspicion or a possibility. Is that qualify as clear and convincing evidence in any way?
Not in my opinion. I mean, I haven't read the reports, haven't read the evidence and reviewed it. But if what you're telling me is true, no, it's not clear and convincing evidence that you were high on drugs.
We're pushing it to trial.
Okay,
so,
good.
We have our pre-trial next week.
Good. That's what you should do.
Next month.
That's what you should do.
Okay. And I'm really trying to be active. I understand that these court-appointed attorneys are overworked and underpaid, so I'm trying to do as much as I can to help her in, preparing my defense without me defending myself. So my next question is, during the CFT meeting that we had with CPS, from the very beginning, the very first time that the father of my son brought my son to go meet the social worker, we've recorded everything. And they say that you can't.
Jay,
Yes,
I'm getting signaled I have about a minute left. Just ask the question. I'll give you a quick answer.
They tell me that I can't record anything, and that, especially during the CTF meeting, I wasn't allowed to take notes or record, that they would take notes and give them to me. Not everything was provided on the notes.
Okay, so let me answer that question. You can't take notes. I've never heard that one. You should talk to your attorney about it. But you can't record unless they give you permission. Now, sometimes I tell people, hey, if they won't let you record, don't have a meeting with them. But you got to talk to your attorney about that. Hey, Jay, I want you to call me at my office, 888-888-6582, and we can talk more about this tomorrow. This is Vince Davis and Cynthia Becker. This is The Secret, How to Fight Child Protective Services and Win. We'll be back after our break.